Whistleblowing Employment Law Scotland. Under the Public Interest Disclosure Act 1998, employees may be protected against dismissal or other penalties when disclosing certain types of information regarding their company's business. Examples of these disclosures generally relate to malpractice or attempts to conceal evidence relating to dangers to health and safety, dangers to the environment, criminal activity including money laundering and tax evasion. Whistleblowing has become an increasingly important part of the employment law landscape. This is in part due to the fact that there is an increased emphasis on encouraging whistleblowing claims, and also in part due to the fact that compensation for whistleblowing claims is unlimited. So what is whistleblower protection? In the UK, workers can disclose certain information and obtain protection in relation to that disclosure. It is not the case that a worker may make any disclosure and claim protection. The disclosure must relate to one of the subject matters defined as a qualifying disclosure. In addition, the worker must follow a set procedure when making a disclosure. In general terms, most qualifying disclosures made to a worker's employer will be protected. Stricter regimes are set if the disclosure is made to someone other than the employer. The intention of the law is to encourage workers to disclose their concerns within organisations where they are employed, and to avoid reckless and irresponsible disclosures. Therefore, unless the matter is exceptionally serious, the employer or an appropriate prescribed person must usually be informed of the matter before it is disclosed more widely, and the worker must act reasonably in making the wider disclosure. So who would be protected? The protection applies to workers, agency workers, workers not obliged to carry out work personally, NHS practitioners and trainees. There are also special provisions that apply to others, such as Crown employees and police officers. Which disclosures are covered? In order to attract the protection of statute, the disclosure must be a qualifying disclosure. What this means is that it relates to any disclosure of information which, in the reasonable belief of the worker making the disclosure, is in the public interest and tends to show one or more of the following: a criminal offence, failure to comply with a legal obligation, a miscarriage of justice, the health or safety of an individual has been endangered, damage to the environment, or concealment of information showing any of the above. A disclosure of information is not considered a qualifying disclosure if the person making the disclosure commits an offence by making it, or if the disclosure would be in breach of the principle of legal professional privilege. So the disclosure of information comes under the term disclosure, and this is not defined in legislation, but has a wide application and can include disclosures made in writing and also verbally. There must be a disclosure of information. Until recently, it was held that a protected disclosure must contain information, the conveying of facts, and not simply voice a concern or raise an allegation. However, in a recent case, the court held that a statement that could be characterised as an allegation could also constitute information, and therefore amount to a qualifying disclosure, and this must be addressed in the context it was made. The public interest requirement. A disclosure made on or after the 25th of June 2013 will only be a qualifying disclosure if the worker reasonably believes that the disclosure is in the public interest. There have been numerous recent cases which have considered the public interest test. Whilst it will be heavily fact-dependent, the court has confirmed that disclosure which is in the private interest of the worker can also be in the public interest in circumstances where it also serves the private interests of other workers too. Concerns raised purely in self-interest are not protected. In order to qualify for protection, a worker must follow one of the set procedures in disclosing the qualifying disclosure. It is important for employers to display whistleblowing policies and guidance within their organisation so as to encourage workers to disclose any reasonable belief of wrongdoing at an early stage. An effective whistleblowing policy allows issues to be raised and corrected internally, therefore avoiding reputational damage which may come from serious breaches in external disclosures. Should you require a whistleblowing policy to be drafted to suit your organisation's needs, or if you are a worker who has concerns about the above, get in touch with our specialist employment team. We specialise in helping workers who believe that they have been treated unfairly as a result of whistleblowing, as well as helping employers who may be considering implementing or revising an existing whistleblowing policy, or they simply wish to provide training on this.